Very good evening, my dear friends. In this session, we will deal with the essentials of the essential elements of a promissory note. Friends, this is under section 4 of the Negotiable Instruments Act. I told you 4, 5, 6, 7 are very important. And section 4 speaks of a promissory note stating that it is an unconditional promise to make payment of a debt. Section 4 says a promissory note is an instrument in writing, not being a bank note of a currency note, containing unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. Here, one issue you have to understand. A promissory note basically payable to bearer is concerned. Actually, it is prohibited in the sense that the RBI Act Section 32 deals with this subject matter, which was repealed, and then you will have to go through the prohibition given under Section 31, where it prohibits this particular bearer promissory notes. However, the provision has been repealed, 31(2). However, the provision under section 58, capital B3, speaks of punishment, which continues. That is the reason why, if you see the 100 rupees note, I promise to pay the bearer. That's the reason why it is a currency note, not a promissory note. You have to make out a distinction between a currency note and a promissory note here. That is the reason why a promissory note indicates an unconditional promise to make payment of a debt. Actually, the provision, if you read, it is an instrument in writing, not being a banknote or a currency note. That's the reason why RBI Act has been referred to, Section 58(b)(3), containing unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of certain person or to the bearer of the instrument. Here, of course, even debt is not mentioned. But without debt, why anybody should give a promissory note? There's a reason why we say so. But the features are concerned. If you see this particular section 4, there are certain vital features which specify that unless these features are contained in the promissory note, in the instrument, it is not a promissory note. What is the importance of that? A promissory note is immediately on demand liable to pay the payment. So, the person who has given a promissory note or endorsed, and then to in whom favor it is endorsed. Now, he is liable to make the payment, or in the sense that the person who writes a promissory note is prima facie liable to pay, in whose favor it is given or endorsed is entitled to collect that particular money. And then that person who has executed this promissory note is liable to make the payment, but not a promissory note which is stated to be payable to bearer because of the prohibition. Even though it is repealed, Section 58B(3) of the RBI Act comes into picture. Now, friends, I request you to go through the provisions of RBI Act 31, then 32, then 50, which of course this is repealed, then 58B(3). By going through the provisions of Section 4, what do you find the features of a promissory note? The promissory note is basically supposed to be in writing. So Section 3 of the General Clauses Act says, writing includes printing, lithography, and any other mode of representing or reproducing words in a visible form. Writing means that. That's the reason why I vehemently advise it time and again last 1.5 years to go through the provisions of General Clauses Act. Whenever there is a lacuna, correct definition is not available, go to General Clauses Act. Otherwise, go to the dictionary meaning and then go to the interpretations of a particular subject matter by the Supreme Court thereon. So here, the first requirement or ingredient or feature of a promissory note is that it should be in writing. The language used should clearly show that there is an unconditional commitment on the part of the drawer, maker, to pay the money. Second point is promise to pay. An express promise to pay must be given where in Bal Mukund versus Munna Lal, Ramji Lal, 1970 Punjab and High Court judgment, the court said, unless an instrument contains an express undertaking to pay, it is not a promissory note. Then again, the third one is certainty, that particular payment should be certain with a particular time factor. That is, it is Carlos versus Frank Court, 1794. The court said the reason that the people were obliged to require when the uncertainty would be reduced to a certainty. Here you have to read Section 5, subsection 2 of the Negotiable Instruments Act, which is to be read with Section 4 with regard to the certainty. 5 is on bills of exchange, 5.1 is on bill of exchange general definition, then 2 is a promise or order to pay is not conditional within the meaning of this section and Section 4 also. By reason of the time for payment of the amount or any installment thereof being expressed to be on the lapse of certain period or on the occurrence of a specified event, which according to the ordinary expectation of mankind is certain to happen, although the time may be uncertain. So what is important here is, certainty means that suppose I say I will pay you 1 lakh rupees on the death of A's father. One day A's father will die. Of course, provided I am also alive, then on the death of A's father, I will pay B this particular amount. Whatever may be the circumstances. Death is certain to happen. But if I say X marries B, then I will pay you 10,000 rupees, then it is not valid. There is a reason why the Negotiable Instruments Act has given various exceptions in this particular case. So now the second point is certainty, and the third one is with regard to the signature. What is signature? Signature indicates consent of the parties of the particular proposal. So writing of a person's name in order to authenticate and give effect to the contract contained in the instrument is the signature, as this is enunciated under section 3, subsection 56 of the General Clauses Act. So the maker of a promissory note may, if he is unable to write, sign, then he can put a mark. What is important, Foster versus Macnon, the English case, it was held that the mind of the person signing should accompany the signature also. That's the reason why if it is done under coercion, etc., then it is not valid. If the signature obtained by misrepresentation also, it would be considered to have been signed as the person making this never intended to sign. Of course, it is voidable. Then friends, the next important aspect is certainty of parties. The maker and payee. No presumption could be allowed here. They must be certain, but the promissory note could be made by description, and it is valid because, like the bank managers. Same is the case happened in Mahant Damodar Das versus Banaras Bank, Patna High Court judgment. Then friends, according to the definition we have seen, there should be certainty of money. And then this is under section 5, read with section 18 of the Negotiable Instruments Act. Then says some payable must be certain and must be capable of contingent additions or subtractions. Smith versus Nightingale, where there is a proposition, I promise to pay a 1,000 rupees and all other sums due to him. The court held it is not a promissory note. Then friends, the money, the promissory note must be undertaken with the legal tender currency of India, so far the Indian Act is concerned. Then the date, place, other issues are sometimes taken on presumption. Of course, place will give jurisdiction, so we had to mention about the place that would automatically come in the address. And then the last point is stamping. Unstamped promissory notes are invalid absolutely. Subsequently, you cannot stamp. There is no question of, in fact, impounding. It's not possible. So friends, with this background, these are all the features of negotiable instrument. I now take you to the examples of section 4, which says, like number 1, I promise to pay B or order rupees 500. It's a promissory note. I acknowledge myself to be indebted to B 1,000 rupees to be paid on demand for value received. Here it is not payable to bearer, so it is valid. Mr. B, I owe you, I express 1,000 rupees. No, it is only expression. It is not a promissory note. I promise to pay B rupees 500 and all other sums which shall be due to him. This is uncertain, invalid. I promise to pay B 500 first, deducting thereout any money which he may owe to me also is not correct. I promise to pay 500 rupees 7 days after my marriage with C, and suppose C does not marry me, so it is not valid. I promise to pay rupees 500 on D's death, provided D leaves sufficient money. This is also not correct. Simply say D's death, then it is correct. It is valid. I promise to pay 500 rupees and to deliver him my black horse on 1st January. This is also not correct. This is not a promissory note. Promissory note means you have to make a demand and it is directly payable on the day it is demanded. And the validity is not, the liability limitation is not from the demand being made, but from the date it was written. So these are all the basic issues which we are supposed to study with regard to the promissory notes, my dear friends. And then the Negotiable Instruments Act contains specific provisions on section 4 with regard to promissory notes, and then this is having a very great value in understanding one of the most important negotiable instruments. So with this background, in the examination point of view, any question comes, you can make out a nice answer, carve out, and give with this case law, you can present your case thereon. So next is bill of exchange, followed by checks. We'll take them also. But I think very soon I will revert to you with that, and then the holder in due course holder and holder in due course. Then 138. With this, we can close the now session. So thank you very much, my dear friends. And then we'll meet very soon because your examinations time is running out. We'll be back. Thank you. Have a nice day. Good day.